Hello everyone, this is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to the October edition of 1 Month to a More Effective Compliance program. This is the only monthly compliance program focusing on a different subject, taking a deep dive so that it will help you have a more effective compliance program. This month, I will be talking about 1 month to more effective compliance for business ventures. But first, a word from this month's sponsor, the Volkov Law Group.
Hi, I'm Mike Volkov of the Volkov Law Group and proud sponsor of this month's podcast series. The Volkov Law Group believes that every company should have a robust ethics and compliance program. Experience and research show that ethical companies are better performers in the global marketplace. At ethical companies, employees believe in the company, they feel vested in the company, and are more productive. As a result, misconduct rates are much lower and financial performance is higher. We can help you achieve these benefits through an effective ethics and compliance program. The Volkov Law Group specializes in corporate compliance, internal investigations, and white-collar defense. We are your partners in our joint mission of building an effective ethical culture for your company. Our 10 years experience shows that business cultures can change. We are committed to work with you to achieve an ethical culture in your company. We address your company's anti-corruption, antitrust, trade and sanctions, anti-money laundering, and other regulatory and legal risks. We do this through practical guidance that your company can easily implement. You can learn more about our commitment to effective ethics and compliance programs at our website, www.volkovlaw.com, our award-winning blog, Corruption, Crime, and Compliance, and our new podcast series of the same name. You can contact me at my email address, mvolkov@volkovlaw.com. Let us know how we can help you achieve your goals.
Thank you, Michael. In this month's series, we will take a look at the role of compliance in mergers and acquisitions, the role of compliance in joint ventures, in joint venture agreements, distributorships, franchises, teaming agreements, partnerships, as well as other types of business relationships. At the end of October, you have an excellent grounding in what you need to do for a business venture under the FCPA. My 1 month series of 1 month to a more effective compliance program running through 2017 is a part of the Compliance Podcast Network. Day 8, Post-Acquisition Integration Dates. Previously, many compliance practitioners had based decisions on the M&A context on DOJ Opinion Release 0802, which related to Halliburton's proposed acquisition of the UK company Expro. This is known as the Halliburton Opinion Release. In 2011, the Johnson & Johnson DPA changed the perception of compliance practitioners regarding what is required of a company in the M&A setting related to due diligence, both pre-acquisition and post-acquisition. And then in 2012, we had two items come up. The first was the Data Systems Solutions, or DS&S DPA, which brought additional information to the compliance practitioner on what a company can do to protect itself in the M&A context. And of course, in November 2012, the FCPA guidance was released, and it spoke about the post-acquisition phase of due diligence, noting that is a part of the compliance process for mergers and acquisitions. Both the DOJ and SEC evaluate whether the acquiring company promptly incorporated the acquired company into all of its internal controls, including its compliance program. Companies should consider training new employees, reevaluating third parties under company standards, and where appropriate, conducting audits on new business units. While the 2012 FCPA guidance discussed mergers and acquisitions in the context of a best practices compliance program, it really didn't focus on the time frames that were laid out in the Halliburton Opinion Release, the J&J DPA, and the DS&S DPA. So that's what I want to go through with you today. The Halliburton opinion release began as a request from the company to the Department of Justice from issues that arose in the pre-acquisition due diligence of the target company. Halliburton submitted a request posing these three questions: whether the proposed acquisition transaction would violate the FCPA, whether through the proposed acquisition of the target, Halliburton would inherit or buy itself FCPA liabilities for the target's unlawful conduct, and whether Halliburton would be held criminally liable for post-acquisition unlawful conduct by the target prior to Halliburton's completion of its post-closing due diligence. And what the answer came back, the way opinion releases work, the Department of Justice does not tell you what the answer is. You propose an answer, and they will opine on that. So that's what happened in this case. Halliburton laid out some deadlines, which the Department of Justice agreed to. And these are very tight deadlines, but they're all predicated on the fact that Halliburton basically, because of anomaly of English law, could do zero or extraordinarily small due diligence on contracts and third-party relationships that Expro had. And indeed, under English law, I believe it's 25 contracts that they got to look at. So here are the deadlines, and like I said, they're very tight. Within 10 days of the closing, Halliburton would present the Department of Justice a comprehensive risk-based FCPA and anti-corruption due diligence work plan, which would address the use of agents and other third parties, commercial dealings with state-owned customers, joint ventures, teaming agreements, consortium agreements, immigration and custom matters, tax matters, and any other government's licenses and permits. The Halliburton work plan committed to organizing their due diligence efforts into high-risk, medium-risk, and low-risk elements, and this is where the really tight time frame came in. Within 90 days of closing, Halliburton would report to the Department of Justice the results of its high-risk due diligence. Within 120 days, Halliburton would report to the Department of Justice the results of its medium-risk due diligence. Within 180 days, Halliburton would report to the Department of Justice the results of its low-risk due diligence. And within 1 year, Halliburton committed to full remediation of any issues which it discovered within 1 year of the closing of the transaction. Based upon these incredibly tight timeframes, the Department of Justice said that there would be no FCPA violation if they got it cleaned up going forward. Next up, we had the Johnson & Johnson Deferred Prosecution Agreement. And here we had, in addition to the at that time, elements of a best practice compliance program, there were something called enhanced compliance obligations, which were a list of compliance obligations J&J agreed to undertake for the duration of the deferred prosecution agreement. So a couple of those are noteworthy that I'll just read. J&J will ensure that new business entities are only acquired after thorough FCPA and anti-corruption due diligence by legal, accounting, and compliance personnel. Second, J&J will ensure that its policies and procedures will be applied as quickly as is practicable, but in no event less than 1 year post-closing to any newly acquired businesses, and will promptly train directors, officers, and new employees to conduct a specific FCPA audit of its newly acquired businesses within 18 months. So we had these two dates of 18 months for the conduct of a full FCPA audit of the acquired company and 12 months to both train and bring the acquired company within J&J's best practices compliance program. And we had the DS&S, Deferred Prosecution Agreement, and under this, it sort of followed the Johnson & Johnson language, but it added the time deadline of as soon as practicable. So up until the time of the FCPA guidance, we had really three time frames. Under the Halliburton Opinion Release 0802, we had the trichotomy of high-risk agents 90 days, medium-risk agents 120 days, and low-risk agents 180 days. Johnson & Johnson, this expanded out to 18 months, and DS&S as soon as practicable. To implement the FCPA compliance training under Halliburton, it was immediately upon closing. J&J, 12 months, DS&S as soon as practicable. And then training on a compliance program. Under the Halliburton opinion release, it was 60 days to complete training for all high-risk employees and 90 days for all others. J&J gave the 12-month time frame, and once again with DS&S, it was as soon as practicable. So this gave us some pretty stout language that was then followed in the November 2012 FCPA guidance, where they kept the language as soon as practicable. But I would have to say, based on these deferred prosecution agreements and opinion releases, you're really going to be under the gun. This means you need to do as much work as you can in the pre-acquisition phase or stage. The DOJ makes clear that rigor is needed throughout your entire compliance program, including M&A. This rigor should be reviewed as something more than complying with the FCPA. It should be viewed internally in your company as making good business sense or operationalizing your compliance program. So what are today's 3 key takeaways? Well, number 1, as I've emphasized throughout this podcast, the Halliburton opinion release put some very tight deadlines into the post-acquisition due diligence and evaluation process, but this was based upon their lack of ability to do it beforehand. 2, J&J and DS&S added some specific post-acquisition requirements and gave you some different time frames, 18 months, 12 months, and as soon as practicable. And number 3, it really doesn't matter which of the time frames you follow, you're going to have to hit the ground post-closing as soon as possible, and you're going to have to hit the ground running. So that means if you can do pre-acquisition due diligence and have a risk assessment, you will be ready to go. If you are not, and you're stuck in the situation that Halliburton found itself with this potential merger with Expro, you're going to have to double down. This is Tom Fox. I hope you've enjoyed Day 8 of 1 month to more effective compliance for business ventures, and I hope you'll join me tomorrow for Day 9. This is Tom Fox again. I'd like to thank you for listening to this episode of 1 month to more effective compliance for business ventures, and I hope you will join me again. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate the podcast, as it would help in our rankings and help get the word out about the only daily podcast which will bring you a more effective compliance program. If you have any questions, you can email me at tfox@tfoxlaw.com. Once again, thanks to this month's sponsor, Mike Volkoff at the Volkoff Law Group. The podcast series, 1 month to a more effective compliance program, is a part of the Compliance Podcast Network. Please join us again.